Thank you, sir.
Ready?
Can I see counsel for a second?
A little mix of everything, right? That's what I told you. Pay attention. Is it going to be a mix of everything? That's what it was. Even the defense said at some point that negligent homicide sounds better than the rest of these charges. They don't even believe their own self-defense story. They're asking you to find them guilty of negligent homicide now? Throwing things against the wall and seeing what sticks. Listen, defense counsel repeating himself over and over again does not make things true. Okay? Consider all the evidence you've heard in this case. Don't consider what the defense counsel said as truth. Recall from your own memories, from your own notes, what you recall. And understand that neither one of us has perfect memories about what the witnesses said. The 12 of you are going to be able to come together and remember things a lot better. So rely on your own memories and notes about what happened in this case. The defense wants to blame the state for, I guess, prosecuting the case. They said that we called it a rampage. No, that's what Shea McConnell called it. When he saw the defendant showing up with a gun. He ran away because he thought the defendant was going to be on a rampage. Those words is what Shea McConnell described it as. He was afraid of the defendant. This idea that the defendant was helping his friends is just ridiculous. He told the police over and over and over, 7 times by his own admission, that he was standing right outside of his car because he was protecting himself. It wasn't until he got here, took the stand and said, well, actually I was protecting my friends, because he had to have a reason, right? That he went 90+ feet. Can't have it both ways. The defense counsel said the defendant waited to the last minute to shoot. Had no other choice. We're just dismissing accountability completely from this case, aren't we? Because the defendant had a choice when he was at his car not to get out of his car and go toward this group. He had a choice not to bring a gun. He had a choice not to call the police or to call the police. He had a choice every step of the way. And just because he made the wrong decision, the wrong choices, doesn't mean he gets off from these charges. The defendant had choices that he made, and he made the choice to retaliate. The defense did a lot of cherry picking just now. And again, rely on your memories and your own notes about what the witnesses testified to. The defense wants you to recall Acevedo's testimony that he saw Nick Prado, who he thought Nick Prado was throwing a punch that night. Remember that? That's what the defense wants you to remember. Not that Nick Acevedo testified that Colin Brew stepped forward with his hands up in a questioning manner. They don't want you to remember that part. Or that Abby Norcutt testified here and said that she saw Nick Prado, a person that surely she would recognize because it was her boyfriend at the time, standing in the street before the shots rang out. Defense wants you to remember that Shea McConnell said he was scared, but not that he said he was also scared of this man over here who's on trial, the defendant, for bringing a gun. Doesn't want you to remember that Shea McConnell said they were never surrounded. Jacob Mike said they were never surrounded. The defense kept saying that Kyle Zentek was going for the gun. Well, if you recall from Kyle Zentek's testimony, what he said was to the police, I might have been going for the gun, maybe. He didn't really remember. What he does remember, what the defense doesn't want you to recall from Kyle's testimony, was that he saw that light shining on him and that he turned to run away. And now the defense wants you to think about that as, well, Kyle was attacking the defendant, so surely he deserved to get 2 shots in the back. Ridiculous. And this trajectory suggesting that he was shooting up in the air. Imagine if Kyle was turning and was in this position. Would he not also get an upward trajectory? Of course. just heard about the paradoxical effect again, alcohol and Xanax. Paradoxical means it's not common, right? It's not what you would expect. Paradoxical, as the doctor told us, Dr. French, happens in 1% of people, maybe as high as 13%, but when Mr. Shea cross-examined him, he said that was in studies where people were already unstable. And so this is not a common occurrence. But the defense wants you to speculate and say, well, that must have been the situation here, surely, without any evidence. Defendant's argument, if you remember what he was saying, was based solely on what the defendant was stating in this case. But you have to consider all the testimony. Remember that instruction that tells you what the defendant says, it has to be measured against all the other evidence, and it has to be measured at the same way as every other witness. So he doesn't get a pass because he took the stand and told you some things that he wanted you to hear. No, you consider his testimony in light of all the other evidence. The defense wants to suggest that there's some conspiracy theory here between the Delta Chis, that somehow they got together and formulated some story to try to pin a murder on somebody. Keep in mind that all the young ladies in Mountain View dorm gave a similar account of what they described. Keep in mind that Jake and Shay gave a similar account of what was observed that night. This is an important point to make, because when the defense asked some of these witnesses, well, did you get together and discuss notes? And they denied it, and they said no. That is the evidence. A lawyer's questions are not evidence. Innuendo, suggestion, that's not evidence. Evidence only comes from the witness stand. So when they said, no, we did not get together, and when they talked about how they talked to the police that very night, that's the evidence. Lawyers' questions are not evidence. Let's talk about the medical examiner, about Colin Brew. The defense was right. He wasn't on flat ground. And he was at a .285 BAC. They want it both ways. You see, they want Colin to be this raging drunk that night, but they also don't want you to think about the fact that he had to step over a 6-inch curb and he was walking on unlevel ground. Is it just as likely that Colin could have been falling in the moment that the defendant shot him? Absolutely. And when they talk about 2 feet away, remember, this is one injury. They're stippling on one of these injuries. And it's not 2 feet away from the defendant, it's 2 feet away from the muzzle of the gun. Keep that in mind. Let's talk about some more speculation that the defense just made. What the blood would have shown at the scene. He suggested that the blood would have shown that there was some attack on the defendant. Really? What evidence is there to support that? That's speculation. One of the jury instructions tells you not to guess about the evidence, meaning you cannot speculate about what the evidence may or may not be. If you didn't hear from the witness stand, then that's what the evidence is. The defense suggests there's some type of analysis, branch analysis, I suppose, to tell you something about what happened to that tree. That the state would have found bullets if they hadn't been shot in the air. Really? What evidence is that based on? What expertise is that based on? This is the most egregious example the defense just gave. That Colin Brew had scabs on his hands because he was fighting at some prior time. Did you hear any evidence from this stand about that? That's improper. What you heard from the witness stand was actually Amanda Conrad, one of the defendant's own witnesses, tell you that Colin was a peaceful person. And when the defense got up and said, would it change your mind if he was at a .285 BAC? No. What if he had Xanax in his system? No. She was adamant that Colin was a peaceful person. That's the evidence, not some speculative argument by the defense. Consider what the defendant was saying, what he lied about. What was inconsistent with the other witnesses? Because there's a pattern. These lies were by design. Remember, he told you that he read the book on self-defense. He knew the buzzwords. So when after he told Officer LaBarre that he was wrong for what he did, then he tells the police, well, there were a lot of people coming at me, and they were saying they wanted to kill me, and I got piled on. All these things that were inconsistent with other witnesses. The only things he really lied about were the things that he tried to use to bolster his false self-defense claim. But by the way, even all these lies put together don't amount to self-defense. The state kept talking about 90 feet because it matters, and the defense kept ignoring it because it matters. It matters because 90 feet shows reflection. 90 feet shows premeditation. 90 feet shows that he was in no apparent danger while he was at his car. The defense wants you to rely on the defendant's own self-serving testimony about, well, I didn't intend on shooting anybody. I didn't intend on killing anyone. Of course he's not going to say that on the stand. So what you have to do is dig a little deeper. Look at the actions. What did he do? What actions refute that statement? There's an instruction that I keep referring to. It's the intent inference. Says you can examine all the facts and circumstances to derive what the defendant's intent was. Actions speak louder than words. The defense, or the defendant, what were his actions? Straight to his car, straight to his gun, and then straight back to shoot the victims in this case. The defense kept saying, of course the defendant was in fear. How can the state argue otherwise? Well, here's an example. The defendant shot two people who were unarmed, Colin Brew, Nick Peering, and then he put his gun away. What happened to those 10 or 12 really dangerous people? I guess he wasn't concerned about them. And then later, after he claims to have been piled on by 5 to 10 people, he puts the gun down. Remember, Chase Jones comes out. The sirens are in the air, by the way. He's got no other options. Defendant has to put the gun down at this point. But he does not unload the gun. He does not remove the magazine to make it safe. With all those dangerous people around, he didn't think to make the gun safe so they couldn't use it against him. Actions speak louder than words. One of the exhibits that was just shown to you, Exhibit 482, just a note on that. Defense was talking about misperceptions, how Nick Prado said, circled this area as where the shots occurred. That wasn't my memory from the testimony. Rely on your own memories and notes. I believe Nick Prado testified that he identified where he first saw the group in that exhibit, 482. Look through your instructions and you'll find that there is no law that says it's okay to just point a gun at people because you have a gun. There is no instruction in there that will tell you what the defense suggested, that it's okay to come up on a group of people and point a gun at them if they're not attacking you, if there's no deadly physical force. Now listen, there was a confrontation. State proved it to you. The state proved that the defendant was punched in the face. The state proved to you that there was a confrontation in the street and that this group migrated, but it wasn't a chase down because Jake and Shay both told you that they were never surrounded, that there was no physical altercation except for those pushes on the ground beyond that, and that the group was dispersing. And Jake said to you that he was sticking around because he wanted to get his hat. That was the level of concern Jake and Mike had. Shay McConnell said about that concern, it was not necessary for there to be a gun. When he saw the defendant with the gun, he ran. The defense keeps misrepresenting how dark it was with those dark photos. You saw the body cam just moments before, Exhibit 353, and the officer's telling you that those photos are not as dark, or are darker, in fact, than what it looks like when you're there. And you know that from your own experience. You know that when you're in a dark place or outside and you're taking a photo, you're going to light up with that flash 10 feet in front of you and everything else is going to be dark. The defense said that the defendant walked 15 feet away from his car, or he said that he walked 15 feet away from his car. That's not what the testimony was. In fact, he claimed that there were guys 10 to 15 feet away from his car when he was trying to get his gun. That was proven false because there's nobody that chased him to his car, and he realized, and in fact he admitted on the stand, that he was alone at his car. What he testified, or what he told the police over and over again, was that he was right in front of his car when he shot two people. And of course, that was wrong as well. And so he had to develop this other theory that he was trying to help Jacob and Shay 90 feet away. The defense suggested that the defendant was under so much pressure, he couldn't make any choices. He was alone in his car. How about picking up your phone and calling the police? You can still do that, by the way, with 1% battery. You know that. How about taking your keys out, turning on the car, and driving away? That was a choice you could have made. How about just arming yourself? If you're so nervous, just arming yourself and staying in your car. Nobody was busting through the windows of the car. Nobody was trying to grab his gun. There was no struggle. All these fast people that were chasing him down strangely never caught him. Because that wasn't what happened. Now, I will agree with one thing the defense said, which is about sympathy. You're not to consider sympathy when you decide this case. Right? The instruction tells you, set that aside. We had this discussion during jury selection. Set that aside. Set aside sympathy. Set aside prejudice when you make your decisions. So when you heard the defense elicit testimony about how distraught the defendant was when he was talking to the police that night, what does that matter? Because he regretted shooting 4 people? Sure, you might be distraught, but you can't consider his emotional state when you consider what he did that night. Because what happened before that was that he got his gun and he walked 90 feet to shoot these people. That does not undo the premeditation. It does not undo the decision he made before he shot these 4 people. Let me circle back to self-defense because I didn't hear the defense attorney describe to you why self-defense even applies in this situation. Now, granted, he said, well, now it's negligent homicide, so maybe they're abandoning that position. But self-defense says it has to be deadly physical force, right? You have to be threatened with the same level of force that you're using. Proportionality. This is an important concept in self-defense. And what is deadly physical force? It's defined for you in this instruction. It says it's force used with the purpose of causing death or serious physical injury, or force which in the manner of its use or intended use is capable of creating substantial risk of death or serious physical injury. Who besides the defendant was using that type of force? Nobody. Nobody was. Self-defense is just out. It does not apply in this case. Secondly, apparent danger. Where was the apparent danger when the defendant was in his car? There was none. When he got out of his car and walked toward the group, he was now the aggressor. He was the one pointing a gun at someone. And by the way, ladies and gentlemen, self-defense goes both ways. Something the defense didn't talk to you about. It goes both ways. When the defendant arrived at that group and pointed the gun in Colin Brew's face, Colin Brew had every right to attack the defendant, to prevent an attack on himself. The defendant was the one that walked 90 feet. Colin Brew is not able to walk 1 or 2 steps to protect himself. It goes both ways. Same thing when the defendant shoots 2 unarmed kids and Nick Plecky is watching from the side and sees what the defendant is capable of, wants to prevent further criminal activity, wants to prevent further injury or death. Nick Plecky is inside his own, he has the right, just like anyone else, to prevent a crime from occurring. He just saw the defendant shoot 2 people. Goes both ways. Regarding defense of another or a third party, there wasn't much discussion on this, but it's still deadly physical force. It still has to be deadly physical force. So when Shay and Jacob describe 0 deadly physical force being presented to them, then it doesn't apply. This instruction does not apply. When Jacob and Shay tell you that they weren't surrounded, even though the defendant assumed or perceived that, although it wasn't reasonable, self-defense does not apply, or defense of others does not apply. You were asked to look at instruction 34, which is an instruction about crime prevention. And one of the things that instruction 34 tells you is that, again, just like self-defense, You can only use deadly physical force if it's reasonable and it's immediately necessary to prevent a crime. What crime was he actually preventing? Because Jake and Shay were not being surrounded, not being attacked. And when he saw that, when he perceived that, he should have known that there was no crime being prevented at that time. There was no crime actually being enacted at that moment. And it has to be aggravated assault with serious physical injury. So you have the instruction about what serious physical injury is. Jacob and Shay were pushed to the ground once. The defendant was not preventing crime. In fact, his statements to the police suggest that he didn't even go over that 90 feet. This is just a new theory that the defense has tried to develop during trial. Now, there's an instruction about a supervening event. And the defense touched on this. I just want to make sure you understand what this is talking about. This is instruction 35. The last, or second to last paragraph says that a superseding intervening event is an event that is unforeseeable by the defendant, and with the benefit of hindsight may be described as abnormal or extraordinary. What did the defendant think was going to happen when he shot two people that were unarmed and there were other people watching? Was it not foreseeable that someone might try to prevent him from shooting other people? Was it not foreseeable that Nick Plecky might try to get the gun away from the defendant? Instruction 35 doesn't apply because there wasn't anything that wasn't foreseeable in that moment after the defendant shot two people. Now, in the verdict form that you'll get from the judge, you need to start from page 1. As the judge instructed you, you start with first-degree murder. All right? That's the charge the defendant is facing. And you deliberate on that. And then you go through the instructions as follows, page by page. When the defense suggested to you that this isn't first-degree murder, or it wasn't second-degree murder, or manslaughter, that maybe it's negligent homicide, I want to talk about second-degree murder with you for a moment, because the defendant testified in this case to a couple things that put him squarely under the category of second-degree murder if you cannot agree as to first. And here's what it says. Where's my clicker? Oh. All right, we're going to have to wait for it to warm up. As you go through these instructions, as the instruction tells you, the very first instruction tells you, you'll find out that some of these instructions don't apply. And some of these instructions may be instructions like self-defense, that won't apply, or defense of others, that won't apply, crime prevention, the things that we've gone through. So second-degree murder is defined in your instructions as well, and it says that the state can prove second-degree murder 3 different ways. The first is that the defendant intentionally caused death, okay? And there's no element of premeditation, just that the defendant intended to cause death of Colin Brew. The second way is that the defendant knew his conduct would cause death or serious physical injury, and it actually ended up in Colin Brew's death. And the third way is that the defendant recklessly caused death, manifesting extreme indifference to human life. I want to focus on this second one. The defendant took the stand in this case, and he said, when I asked him, what happens when you shoot someone in the chest? What did he say? He said, a lot of the times it's fatal. And then I asked him, or it would cause serious physical injury, right? And he said, yes. Right here, even the defendant admits what he did was second-degree murder. If it ain't self-defense, then it's surely second-degree murder. This is the minimum. This is the floor. You shouldn't have to go beyond second-degree murder because this is what the defendant admitted on the stand. Now, the defense suggested, well, there's this other instruction about manslaughter. Well, manslaughter doesn't apply, and here's why. Because there has to be adequate provocation. And this instruction tells you that words alone are not sufficient to reduce it to manslaughter. Words alone. Did Colin Brew ever put a finger on the defendant? No. There's zero evidence that he did anything beyond words. And in fact, we didn't even hear words from Colin Brew toward the defendant. Must not have been a cooling off period. This is the same idea behind premeditation. If the defendant went to his car 150 feet away, he was at his car for a moment, he got his gun out, and then he walked 90 feet. There was over 240 feet of cooling off period, of time and travel that elapsed. And then the last point, the provocation must have been from the victim who was killed. Again, the Colin Brew, from all the evidence you've heard, didn't do anything toward the defendant except, as the defense wants to characterize it, charge the defendant. But you've heard from other witnesses that this charge was simply a step forward or a lunge. And when I asked Jay McCollum to describe what a lunge was, he did this, step forward. So manslaughter doesn't apply. A negligent homicide I won't even waste your time on, because that doesn't apply. The defendant said he intended to shoot these people. He intended to shoot Colin. He intended to shoot Perry. This wasn't a negligent act. So as you go along, you will be eliminating instructions and deciding that some things don't apply. You don't have to be unanimous as to the theory. And what I mean by that is, as to second-degree murder, you don't have to be unanimous. But as to first-degree murder, which is where you start, and which is what the state is asking you to find, you don't have to be unanimous as to the theory behind that either. So for instance, some of you may believe that the defendant reflected in the moment he went to his car 150 feet. Some of you may believe it was at his car where he reflected. Some of you may believe it was during the 90 feet that he walked back. And some of you may believe it was in the moment when he had the gun pointed at Colin Brew and he was waiting. Is Colin Brew, is this person going to step toward me? Is he going to confront me, challenge me, now that I have the power? The reflection could have been in that moment as well. Only the elements have to be unanimous. The defense talked to you about the burden. The burden is beyond a reasonable doubt. That's the state's burden. The state embraces that burden. And what that says, what the instruction tells you, is that the state need not prove the case beyond any doubt or all doubt, but beyond a reasonable doubt. And at this point, ladies and gentlemen, you should be firmly convinced about what the defendant did in this case, about the design of his lies, about what the victims testified to, and the young ladies from Mountain View Dorm, and how it all comes together to form a picture of murder and of an unjustified shooting. And because of that, the state is asking you to find him guilty as charged on first-degree murder and all counts of aggravated assault. Thank you.
Thank you, Mr. Barker. Be ready. Members of the jury, at the start of trial, we all felt that it would be wise to have two alternate jurors in case someone got sick or was otherwise unable to complete their service. To make the selection of the alternate juror fair, we wait until the end of the trial, and then we'll draw the name of two of the jurors at random. And those jurors will be excused and will not participate in the verdict deliberations. However, the two jurors who will be excused will not be released from the admonition, because it may be necessary to bring one or both of the jurors back in case one of the 12 jurors who are deliberating are unable to complete those deliberations. Sometimes the jurors who are chosen may feel disappointment, or they may feel relief. I don't know how the alternate jurors who are about to be chosen here will feel. But I want them to know, on behalf of the prosecution, Mr. Jones, and defense, and myself, how deeply we appreciate your being on our jury and giving us and our county your service.
First one, juror number 11.
Oh, hold on, sir. 1 second.
And juror number 14.
Now, folks, again, I want to personally thank you for your service here to our county and to all the parties in this case. What I'm going to ask you to do is leave your notebooks with Cheryl. Once the jury has reached their verdicts, you'll be notified as to what those verdicts are. And again, all of your notes will be destroyed in this case. So on behalf of, again, all the parties, our county and myself, thank you. You are excused. No, we just those, yeah, those two. Yeah, those two. Okay. Okay. Thank you. Please be seated. Folks, as I indicated in the last jury instruction, in a few minutes you're going to go to the jury room. You'll then discuss and vote on the case until you've reached your verdicts in this case. We will give you the exhibits that have been admitted into evidence. We know that some of them are digital imagery, and we are working to provide a computer to help you view those exhibits if you wish to view them. Also, there was, I want to let you know, there was obviously a weapon that was admitted into evidence, as well as the magazine and the live rounds. We will make the gun available to you to view, but once you've determined that you've examined that exhibit as you wanted to, and you want to see the bullets or the magazine, we'll remove the gun and then we will give you the magazine with the live rounds. Now, again, before you get started, sometimes you have some personal matters that you want to attend to. That's fine. The door to the jury room will be left open. Once you've settled down and started to deliberate, the jury room door is going to be closed. I want to emphasize everything you do in there will be secret and confidential. The bailiff will be able to hear a knock on the door, though, so if you need anything, just knock. Now, again, I went over somewhat about the questions that you have. Use your juror question forms if you have any questions for us. Again, please be patient. I do have to get the attorneys together. We do have to review the question, and we have to determine the answer to be given to you, and then we have to send it back to you. Now, if mealtime comes during your deliberations, then we will feed you at county expense. Please understand that would not come from the cottage place or someplace like that. We do have some menus back there, and we would just simply ask that you order off the same menu. It will make it easier for my judicial assistant and I to pick up the food and bring it to you. If you're working close to 4:30, I'll simply ask what your plans are. Again, you can set your schedule and vary it to meet your needs. But you have to let me know what that is, and then I get the final say. I understand that no one can tell you how to reach your verdict. All I can say is that you start by electing a foreperson to preside over your deliberations. You then discuss the case and vote on it until all of you agree on your verdict. Next, you have to fill out the verdict forms as I indicated. You'll notify either Cheryl or Eli. Once you've told the bailiff that you have a verdict, the bailiff must notify everyone and see that they are collected together in the courtroom. Please be patient. This may take a while. The foreperson should keep all of the verdict forms and bring them into the courtroom. All the notepads should be gathered and given to the bailiff, who will see that they are destroyed. Finally, we will come back to the courtroom and the verdict will be presented to me. I will inspect the verdict forms. I'll give them then to Marie, who will read them into the record out loud. Counsel, are there any matters that we should address before we allow the jurors to begin deliberations?
Not from the state.
Not from the defense, Your Honor.
All right. Is it going to be both you and Eli? All right, Cheryl, if Eli and you would come forward, please.
And attend to them during all their deliberations. While in your charge, you will allow no one to communicate with them nor do so yourself, unless required in the legal discharge of your duties, that you will return them into court when they have arrived at a verdict. So help you God.
Thank you, folks. All right, folks, we stand at recess pending the jury's deliberations. All right, courtroom can now be seated. Are there any matters outside the presence of the jury that we need to address? State?
Not from the state.
Mr. Davidson?
I want to make a record of one issue, if I could, Judge.
Go ahead.
Your Honor, during the course of the closing arguments, the prosecution, I believe in their first closing, made if not a direct argument, an inference or insinuation to the jury that Mr. Jones did not make any assertion or articulate any self-defense claim until after he was in a police audience or something along those lines. The prosecutor knows that's not true, because it was the prosecution that filed their motion in limine to preclude what they characterize as self-serving hearsay statements that Mr. Jones made very early on. He was in police custody, along the lines of, please help me, why did they punch me, why did they chase me? These were statements he made in the car long before he was transported to the police station and had a police audience. I don't think it's appropriate for either side, particularly when that particular side is the one that was the proponent of evidence being precluded, to, if not directly suggest to the jury that there's evidence there, not there. When they know it exists, they just happen to have it precluded. Similarly, Judge, there was absolutely no question, answer, or anything else in the record in this case about Mr. Jones' demeanor while he was testifying, and that was also argued by the state. Third, and most concerning, Judge, excuse me, as you recall, we had a lot of discussions over the past few working days about which justification instructions would be given and which ones wouldn't. The defense wanted a defensive display of a firearm instruction. The state objected to it. The court didn't give it, excuse me. When we discussed that, Judge, it was basically understood, if not represented by the state, that they weren't going to be arguing or insinuating that Mr. Jones was acting outside the law or that he was breaking the law when he had the gun in his possession from the time he was at the car until the time the shooting occurred. Well, that's exactly what Mr. Barker just insinuated. And I think when the court withholds an instruction that's predicated on an understanding, excuse me, or representation by the state that they're not going to make a certain argument, that's a problem. And so for those reasons, collectively, Judge, I would ask for a mistrial.
Mr. Barker.
Thank you. I did not make any inference to the fact that the defendant may have made other statements. I'm talking about the first argument made by the defense. I was very specific in my wording. And know this, Judge, that when I talked about this with Mr. Shea, we made it very clear that the statements the defendant made to Nick Acevedo, Nick Plecki, and Debbie Lubaro, I was very specific about. These are the statements he made to these three people. I wasn't referencing any other statement he may have made. I wasn't suggesting that he didn't make any other statements. But these statements in particular were relevant because they showed that in the very first moment, at least, with Nick Acevedo, the very first statement he made was, I don't know. And then Nick Plecki, the only statement he heard was, what did I do? And Deputy Lubaro, consistent with the testimony, was, I did something wrong, or nobody did anything wrong but me. So there is no suggestion beyond that, what I stated in my first close. Secondly, there was testimony. In fact, defense counsel knows this because he was the one doing direct exam of the defendant and asked him what kind of emotional state. This came out 2 or 3 different times. And the defendant testified that I was crying at different times, or I was emotional at different times, or distraught at different times. The record will bear that out. The third thing regarding defensive display, I was not arguing that the defendant committed a crime when he had a gun in his hand. What I'm arguing is that he reflected and he walked toward the group with the intent to hurt somebody. That's the problem. So for all those reasons, it should be denied summarily. Thank you.
I am going to, I think there's some issues that were a little bit concerning. I tried to, as best I could, reflect on the testimony that was given. I think that I think at this point, though, that the error, if any, did not rise to a level to grant the motion for mistrial. The motion is denied.
Your Honor, sorry. The alternative, would the court consider amending the jury instructions to provide the jury a defensive display justification instruction at this point?
Judge, again, I wasn't arguing that the defendant couldn't display a weapon. The problem is the defendant went and pointed at someone's face. That's the argument I made. It has nothing to do with defensive display. And the defendant isn't charged with displaying a weapon. So there's no reason to give that instruction.
Your Honor, when counsel flips through the instructions addressing the jury in closing argument and challenges them to find an instruction in there that says what Mr. Jones was doing is not illegal, if that's not an insinuation, I don't know what is.
Well, I think that the defensive display of a weapon is a justification for the display of the weapon, or perhaps a disorderly conduct with a weapon. I think in this case, and I think what I heard was not that there was anything wrong with Mr. Jones walking to the place where ultimately the young men were shot with a weapon, but that the walking to the place with a weapon was the act of premeditation in this case. My concern is that the jury may have a tendency to think that the defendant, that they should consider that the defendant did something wrong if we give them, in essence, a defensive display justification, even though he was not charged with anything that brought a charge for wrongful display of a weapon. So I'm going to deny the motion to submit a defensive display instruction.
Judge, just one other thing on the record, not related to this, but we are making contacts to make sure we can get software downloaded to that computer, so we'll have that available this afternoon, hopefully. So I'll inform the court when that happens.
All right. To the family of the victims, to prosecution, to Mr. Jones and Mr. Jones' family and defense, I know this has been a very difficult case. As I indicated outside the presence of the jury, there's an awful lot of pain here, but I want to thank the attorneys for the manner in which they have represented their respective clients. I think all of you have done an outstanding job, and it was an honor to preside over this trial. We'll go ahead and stand at recess.
Thank you, Your Honor.